Question 1. Homicide and the felony murder rule. In a high-stakes environment where multiple challenges arise during a criminal investigation, a defendant is charged with first-degree murder under the felony murder rule. The prosecution argues that the defendant, while committing an armed robbery, unintentionally caused the death of a store clerk when the clerk suffered a fatal heart attack due to extreme stress. The defense contends that the defendant did not directly cause the death and should not be liable. Murder. Based on the felony murder doctrine, which of the following is the strongest argument for the prosecution? A. The defendant did not intend to kill but engaged in a felony inherently dangerous to life, which resulted in death. B. The clerk's death was due to pre-existing medical condition, making the defendant not responsible. C. The defendant's lack of intent to kill negates criminal liability under the felony murder rule. D. Felony murder only applies if the defendant personally and directly causes the death. Answer. A. The defendant did not intend to kill but engaged in a felony inherently dangerous to life, which resulted in death. Explanation. Under the felony murder rule, a defendant can be charged with murder if a death occurs during the commission of a felony regardless of intent. Many jurisdictions recognize inherently dangerous felonies, e.g. robbery, burglary, arson, as the basis for felony murder liability. Courts typically apply proximate cause or agency theory in determining liability. The proximate cause theory holds that if the felony sets off a chain of events leading to death, the felon is liable. In this case, the armed robbery created extreme stress leading to the clerk's fatal heart attack, fulfilling the causation requirement. Option B is incorrect because the felony murder rule does not require the victim to be in perfect health. It only requires that the defendant's felony contributed to the death. Option C is incorrect because intent to kill is not required for felony murder. Intent to commit the felony suffices. Option D is incorrect because courts often hold felons liable even if the death occurs indirectly, as long as it results from the felony. Relevant law. Model Penal Code SS 210.2 Common Law Felony Murder Doctrine. Question 2. The exclusionary rule and the Fourth Amendment. While investigating inconsistencies across various units in a police department's handling of search and seizure procedures, defense attorney challenges the admission of key evidence in criminal trial. The evidence was obtained during warrantless search of the defendant's home, where law enforcement found illegal firearms and narcotics. The prosecution argues that the officers acted in good faith. Defense claims the search violated the Fourth Amendment. Under the exclusionary rule, which of the following is the strongest argument for suppressing the evidence? A. The good faith exception applies, making the evidence admissible. B. The search was conducted without warrant and does not fall under any established exceptions. C. The presence of illegal firearms and narcotics creates an exigent circumstance justifying the search. D. The exclusionary rule only applies if officers intentionally violated constitutional rights. Answer. B. The search was conducted without a warrant and does not fall under any established exceptions. Explanation. The Fourth Amendment protects individuals from unreasonable searches and seizures. Generally, searches conducted without a warrant are presumed unconstitutional unless an exception applies. The exclusionary rule prohibits the use of evidence obtained through unconstitutional searches, with some exceptions such as consent if voluntarily allows a search, exigent circumstances, immediate danger or evidence destruction search incident to a lawful arrest. Automobile exception, reduced expectation of privacy in vehicles, plain view doctrine. Here option B is correct because no warrant was obtained and no exception appears to apply. The exclusionary rule would therefore bar the evidence. Option A is incorrect because the good faith exception applies when officers rely on a defective warrant, not when they conduct a warrantless search without justification. Option C is incorrect because exigent circumstances require an immediate threat or risk of evidence destruction, which was not demonstrated here. Option D is incorrect because the exclusionary rule applies regardless of intent. An unlawful search is enough to trigger exclusion. Relevant law. Mapp v. Ohio, 1961. Fourth Amendment, Weeks v. United States, 1914. United States v. Leon, 1984. Good faith exception. Question 3. Mens rea and criminal intent. During a major transformation where existing methods of prosecution are being reviewed, a state legislature debates whether to change the standard for proving criminal liability in cases involving reckless conduct. The defendant is charged with involuntary manslaughter after causing a fatal car accident while texting and driving. The prosecution argues that the defendant's actions were reckless, while the claims that the conduct was merely negligent. Which of the following best distinguishes recklessness from negligence in criminal law? A. Recklessness requires knowledge of the substantial risk created, whereas negligence only requires failure to perceive the risk. B. Negligence and recklessness are interchangeable and treated the same in criminal law. C. Negligence requires conscious disregard for risk, while recklessness only requires carelessness. D. Recklessness requires proof of intent to cause harm, while negligence does not. Answer: A. Recklessness requires knowledge of the substantial risk created, whereas negligence only requires failure to perceive the risk. Explanation: mens rea, mental state, is a critical element in criminal law. The distinction between recklessness and negligence is significant in determining criminal liability. Recklessness involves a conscious disregard of a substantial and unjustifiable risk. The defendant must be aware of the risk but choose to ignore. Negligence involves a failure to perceive a substantial risk that a reasonable person would recognize. It is a lower standard of culpability than recklessness. Option A is correct because it accurately describes how recklessness requires knowledge of the risk, while negligence does not. Courts apply this distinction in cases involving vehicular manslaughter, endangerment, and other reckless crimes. Option B is incorrect because recklessness and negligence are separate legal standards, with recklessness carrying a higher level of culpability. Option C is incorrect because it reverses the definitions. Recklessness requires awareness of risk, while negligence does not. Option D is incorrect because recklessness does not require intent to harm, only intent to engage in the dangerous conduct. Relevant law. Model Penal Code SS 2.2, United States v. Jewell, 1976, New York Penal Law SS 15.5. 3. Recklessness definition. Question 4. In an environment where different components must interact seamlessly to uphold legal accountability, a criminal defense attorney is evaluating whether to raise the defense of duress. 4. A client accused of armed robbery. The client, Alex, claims that he was forced to participate in the crime under threat of immediate death from an armed gang member. However, Alex had prior opportunities to inform law enforcement but failed to do so, and the evidence that he voluntarily remained in the gang for months before the robbery occurred. Given these facts, which of the following best explains the applicability of the duress defense in this case? A. The duress defense applies because Alex was under immediate threat of death, which negates criminal liability. B. The duress defense does not apply because Alex had prior opportunities to escape or inform the police. C. The duress defense applies because Alex's subjective fear of harm was reasonable even if he failed to report it. D. The duress defense does not apply because duress is never valid defense to violent crimes like armed robbery. Answer B. The duress defense does not apply because Alex had prior opportunities to escape or inform the police. Explanation: the defense of duress requires that the defendant acted under an immediate and unavoidable threat of death or serious bodily harm with no reasonable opportunity to escape or seek help. In United States v. Bailey, 1980, the Supreme Court ruled that duress cannot be invoked if the defendant had a reasonable chance to defeat or inform authorities. Here's why the other answers are incorrect. A. Incorrect. While immediate threat is an element of duress, it does not automatically negate criminal liability if the defendant had alternatives, as in this case. C. Incorrect. Subjective fear alone is insufficient. The courts assess whether a reasonable person in the same situation would have reported the threat or escaped. D. Incorrect. Duress can be defense to many crimes, but courts are reluctant to allow it in violent crimes where innocent third parties are harmed, though it is not an absolute bar. Question 5. During a seamless transition where continuity must be maintained in criminal investigations, a detective is analyzing a case of embezzlement involving a corporate executive. The executive allegedly manipulated financial records to funnel company funds into personal accounts over 5 years, concealing the activity through complex offshore transactions. The defense argues that the statute of limitations has expired. Which of the following principles is most relevant in determining whether the prosecution can proceed? A. The statute of limitations begins when the first act of embezzlement occurs, meaning the case is likely time-barred. B. The statute of limitations is told until the fraud is discovered, allowing the prosecution to proceed. C. The statute of limitations does not apply in white-collar crimes involving corporate officers. D. The statute of limitations applies only if the defendant has not left the jurisdiction within the last 5 years. Answer B. The statute of limitations is told until the fraud is discovered, allowing the prosecution to proceed. Explanation. In financial crimes like embezzlement, courts apply the discovery rule, meaning the statute of limitations does not begin until the crime is discovered or reasonably should have been discovered. Under 18 U.S.C. SS 3282, federal law generally provides 5-year statute of limitations for white-collar crimes, but exceptions exist for ongoing fraud. In Towsey v. United States, 1970, the Supreme Court held that statutes of limitations should be strictly construed, but courts often recognize a continuing offense doctrine for complex financial crimes. Here's why the other answers are incorrect. A. Incorrect. If the statute at the first act, it would incentivize criminals to commit fraud slowly over time. Courts avoid this outcome. C. Incorrect. Corporate officers are not exempt from statute of limitations. Defenses that their fraud may fall under extended tolling provisions. D. Incorrect. While fleeing the jurisdiction can toll statutes of limitations, it is not the sole determinant in white-collar crime cases. Question 6. When developing a solution that must address opposing needs in criminal procedure, a trial judge faces a motion to suppress evidence obtained through a warrantless search. Police officers entered the suspect's home without warrant after hearing screams inside. They found illegal firearms in plain view and later charged the suspect with illegal possession. Which of the following best explains whether the evidence is admissible in court? A. The evidence is inadmissible because warrantless home searches always violate the Fourth Amendment. B. The evidence is admissible because the police acted under the exigent circumstances exception. C. The evidence is inadmissible because even under exigent circumstances, warrant was required before seizing firearms. D. The evidence is admissible only if the suspect later consented to the search. Answer B. The evidence is admissible because the police acted under the exigent circumstances exception. Explanation. The Fourth Amendment protects against unreasonable searches and seizures, but exigent circumstances allow warrantless searches when immediate action is necessary. In Brigham City v. Stewart, 2006, the Supreme Court upheld that police may enter a home without a warrant if they reasonably believe someone inside is in danger. The new doctrine further allows officers to seize illegal items in plain sight. Here's why the other answers are incorrect. A. Incorrect. The Fourth Amendment has exceptions, including exigency, consent, and plain view. C. Incorrect. Once officers legally enter under exigent circumstances, they can seize evidence in plain view without an additional warrant. D. Incorrect. Consent is an independent justification for warrantless search, but it is not required. Exigent circumstances apply. Question 7. During an emergency response where multiple areas are impacted by criminal activity, law enforcement conducts mass arrests at a political protest that turned violent. The defense attorney argues that the client's First Amendment rights were violated and that their detentions were unlawful. What legal principles will most likely determine the validity of the arrests? A. Mass arrests at protests are always unconstitutional because they chill free speech. B. Arrests are valid if there was probable cause that specific individuals engaged in unlawful conduct. C. The government can detain all protesters indefinitely without charges during a state of emergency. D. First Amendment rights always override law enforcement actions, even in violent protests. Answer. B. Arrests are valid if there was probable cause that specific individuals engaged in unlawful conduct. Explanation. The First Amendment protects freedom of speech and assembly, but it does not grant immunity from lawful arrests. In Terry v. Ohio, 1968, the Supreme Court held that probable cause is required for arrest. Courts distinguish between peaceful protesters and individuals engaged in criminal conduct as C. Edwards v. South Carolina, 1963, and Brandenburg v. Ohio, 1969. Here's why the other answers are incorrect. A. Incorrect. Mass arrests are not automatically unconstitutional if based on individualized probable cause. C. Incorrect. The government cannot detain individuals indefinitely without charges, even in emergencies under habeas corpus Article I, Section 9 of the U.S. Constitution. D. Incorrect. The First Amendment does not protect violent or unlawful actions per Brandenburg v. Ohio. Question 8. During the introduction of new methods where coordination between law enforcement agencies is crucial, a federal task force is created to combat an increase in cybercrime. A suspect is arrested for hacking into a government database and accessing classified information. The prosecution charges the suspect under both state and federal laws, arguing that the act constitutes a violation of multiple statutes. The defense claims that the suspect cannot be prosecuted under both jurisdictions due to double jeopardy protections under the Fifth Amendment. Which of the following legal principles applies in this scenario? A. The dual sovereignty doctrine allows both state and federal governments to prosecute the same act separately. B. The double jeopardy clause prohibits both state and federal prosecution for the same crime. C. The ex post facto clause prevents prosecution under new laws that were not in effect at the time of the crime. D. The commerce clause limits federal prosecution unless interstate commerce is involved. Answer A. The dual sovereignty doctrine allows both state and federal governments to prosecute the same act separately. Explanation. The dual sovereignty doctrine states that separate sovereign entities, such as state and federal governments, can prosecute an individual for the same conduct without violating the double jeopardy clause of the Fifth Amendment. The Supreme Court has upheld this principle in cases such as Gamble v. United States 19, reaffirming that state and federal authorities have independent legal interests in prosecuting offences. Incorrect answers. B. The double jeopardy clause does protect against being tried twice for the same offence, but only within the same jurisdiction. Since state and federal governments are distinct sovereigns, they may each bring charges. C. The ex post facto clause applies to laws that retroactively criminalise an action or increase penalty, which is not relevant in this case. D. The Commerce Clause governs federal jurisdiction over economic activity but does not prohibit federal prosecution in cybercrime cases, especially when classified government data is involved. Question 9. In a case where multiple parties have different objectives, law enforcement agencies are investigating an organized crime syndicate involved in drug trafficking. Several members of the syndicate are arrested, and prosecutors charge them under conspiracy laws. One of the defendants argues that they withdrew from the conspiracy before any illegal actions occurred and should not be held liable. What must the defendant prove to successfully claim withdrawal? Conspiracy. A. The defendant merely stated their intent to withdraw but took no further action. B. The defendant informed law enforcement of the conspiracy before any criminal act occurred and took steps to prevent the crime. C. The defendant did not participate in the planning of the conspiracy but remained silent about it. D. The defendant ceased communication with co-conspirators after learning about the plan but did not notify authorities. Answer B. The defendant informed law enforcement of the conspiracy before any criminal act occurred and took steps to prevent the crime. Explanation. Withdraw from a criminal conspiracy is a valid defense, but it requires affirmative action. Courts generally require a defendant to prove they communicated their withdrawal to all co-conspirators, they took steps to prevent the crime from occurring, such as notifying law enforcement. Cases like United v. Hyde, 1997, demonstrate that mere silence or passive disengagement is not enough, but there must be an active effort to counteract the conspiracy. Incorrect answers. A. Stating an intent to withdraw is insufficient without affirmative actions. C. Not participating in planning does not absolve liability once part of a conspiracy. D. Ceasing communication does not constitute a withdrawal unless law enforcement is notified. Defendant actively attempts to thwart the conspiracy. Question 10. During an emergency response where multiple areas are impacted, a police officer responds to a burglary in progress. The officer arrives without a warrant and observes the suspect inside the house attempting to flee. The officer enters without knocking and arrests the suspect. The suspect later claims that the officer's warrantless entry violated the Fourth Amendment's protection against unreasonable searches and seizures. Which of the following justifies officer's actions? A. The exigent circumstances doctrine allows warrantless entry if urgent action is needed. B. The exclusionary rule prohibits evidence obtained without warrant from being used in court. C. The good faith exception applies when an officer believes warrant is unnecessary. D. The plain view doctrine allows entry if the officer can see illegal activity from outside. Answer A. The exigent circumstances doctrine allows warrantless entry if urgent action is needed. Explanation. The exigent circumstances doctrine is an exception to the Fourth Amendment's warrant requirement when law enforcement faces an immediate need to act. In Kentucky v. King 2011, the Supreme Court upheld warrantless entry when there is risk of suspect escaping, destruction of evidence, or imminent danger. In this case, the suspect was fleeing, justifying immediate police action. Incorrect answers. B. The exclusionary rule applies to unlawfully obtained evidence but does not restrict all warrantless entries. C. The good faith exception allows evidence from invalid warrants, but here, no warrant was sought. D. The plain view doctrine allows seizure of evidence without warrant but does not permit entry into private property without cause. Question 11. During a major transformation where existing methods are being replaced, the government agency is implementing a new digital record-keeping system to improve efficiency. However, during the transition, a cyber attack occurs, compromising sensitive citizen data. The agencies at department have been aware of potential security vulnerabilities, but failed to implement timely safeguards. Citizens affected by the breach file a lawsuit against agency claiming negligence. Under what legal principle could the government agency be held liable? A. Sovereign immunity prevents government entities from being sued for negligence. B. The public duty doctrine limits liability unless a specific duty to individuals is established. C. Government agencies are automatically liable under the Federal Tort Claims Act (FTA). D. The agency can be held liable under the concept of gross negligence if it knowingly ignored risks. Answer D. The agency can be held liable under the concept of gross negligence if it knowingly ignored risks. Explanation. While sovereign immunity generally protects government entities, exceptions exist under the Federal Tort Claims Act (FTA) if an agency exhibits gross negligence, meaning it knew of significant risk but failed to take reasonable precautions. It may be held accountable, in this case failing to secure sensitive, despite known vulnerabilities, could meet this standard. Incorrect answers. A. Sovereign immunity does not apply if exceptions under the FDCA allow claims. B. The public duty doctrine applies mainly to law enforcement and does not broadly shield negligence. C. The FTA allows claims against the government, but liability depends on specific circumstances like gross negligence. Question 12. In a situation where formal requirements conflict with practical enforcement, a state legislature enacts a law requiring all businesses to install security cameras to prevent shoplifting. However, the law does not specify penalties for non-compliance. A business owner challenges the law, arguing that it is unenforceable due to its lack of specific consequences. What legal doctrine could be applied to assess this argument? A. The void for vagueness doctrine, which invalidates laws lacking clear standards. B. The rational basis test, which evaluates whether laws serve a legitimate government interest. C. The necessary and proper clause, which grants lawmakers discretion in enforcement. D. The supremacy clause, which determines federal authority over state laws. Answer A. The void for vagueness doctrine, which invalidates laws lacking clear standards. Explanation. The void for vagueness doctrine prevents laws that fail to provide clear guidelines for enforcement. If a statute lacks a defined penalty or is ambiguous in application, courts may find it unenforceable. Incorrect answers. B. The rational basis test assesses legitimacy, but vagueness concerns clarity, not reasonableness. C. The necessary and proper applies to federal lawmaking powers, not state regulations. D. The supremacy clause governs conflicts between state and federal law, which is not relevant here. Question 13. During an emergency response where multiple areas are impacted, a state government declares a disaster due to a severe hurricane. Authorities issue mandatory evacuation orders, but some residents refuse to leave. To enforce safety measures, the National Guard is deployed to assist law enforcement. A resident files a lawsuit arguing that the use of military forces for domestic law enforcement violates federal law. Under which legal principle could the government justify its actions? A. The Posse Comitatus Act prohibits any military involvement in domestic matters. B. The Stafford Act authorizes federal assistance but does not permit military enforcement. C. The Insurrection Act allows military involvement in specific emergency situations. D. The Fourth Amendment prohibits military enforcement without a judicial warrant. Correct answer. C. The Insurrection Act allows military involvement in specific emergency situations. Explanation. While the Posse Comitatus Act (PCA) generally restricts military involvement in domestic law enforcement, the Insurrection Act provides an exception for situations where state authorities cannot maintain order during emergencies. The President or a state governor may invoke it to deploy the National Guard in disaster scenarios. Incorrect answers. A. The Posse Comitatus Act applies but has exceptions for the Insurrection Act. B. The Stafford Act facilitates disaster aid but does not permit military enforcement. D. The Fourth Amendment governs searches and seizures, not military deployment. Question 14. When implementing new protocols in a shared environment, a city introduces a traffic camera system to enforce speeding laws. The driver is issued a ticket based on automated footage, but they argue that this violates their Sixth Amendment right to confront witnesses. What legal argument supports the use of traffic cameras? A. The Sixth Amendment applies only to criminal trials, not civil infractions. B. Automated enforcement must include live testimony from law enforcement. C. The Fourth Amendment prohibits evidence obtained without a physical officer's presence. D. The 10th Amendment prevents the federal government from regulating local enforcement. Answer A. The Sixth Amendment applies only to criminal trials, not civil infractions. Explanation. Traffic violations captured by automated cameras are generally considered civil infractions, not criminal cases. Since the Sixth Amendment right to confront witnesses applies only to criminal prosecutions, courts have upheld camera-based enforcement as constitutional. Incorrect answers. B. Requiring live testimony is unnecessary for civil penalties. C. The Fourth Amendment applies to searches but does not bar automated enforcement. D. The 10th Amendment concerns federal-state powers, not local law enforcement. Question 15. While analyzing the root causes of sequential problems in corporate fraud cases, a federal agency investigates a company accused of falsifying financial reports. The agency demands documents without a warrant, claiming authority under administrative subpoena powers. The company refuses, arguing this violates the Fourth Amendment. How might a court rule on the agency's demand? A. Administrative subpoenas are valid if they serve legitimate government interest. B. The company can refuse without warrant under Fourth Amendment protections. C. The exclusionary rule automatically bars any evidence obtained in this manner. D. The agency must obtain court order before requesting any documents. Answer A. Administrative subpoenas are valid if they serve a legitimate government interest. Explanation. Courts have upheld administrative subpoenas in regulatory investigations if they are reasonable and relevant to lawful inquiries. United States v. Morton Salt Company. Unlike criminal searches, these subpoenas do not always require a warrant. Incorrect answers. B. The Fourth Amendment applies but allows for administrative searches. C. Exclusionary rule applies mainly to unlawful criminal searches. D. A court order is unnecessary if subpoenas are lawfully issued. Question 16. During an emergency response where multiple areas are impacted, the state experiences a sudden spike in COVID-19 cases. The governor issues an executive order mandating vaccination for all public sector employees. Several employees refuse, citing religious objections. They file a lawsuit arguing that the mandate violates their First Amendment rights. How might the court analyze this claim? A. The mandate is unconstitutional because it forces individuals to violate their religious beliefs. B. The government can enforce the mandate if it passes strict scrutiny by proving a compelling interest. C. The government can enforce the mandate if it passes the rational basis test. D. The mandate is automatically lawful because public sector employees have fewer rights than private employees. Answer. B. The government can enforce the mandate if it passes strict scrutiny by proving a compelling interest. Explanation. Under the First Amendment's free exercise clause, the government cannot impose laws targeting specific religious practices. However, in Employment Division v. Smith, 1990, the Supreme Court ruled that neutral laws of general applicability are not subject to strict scrutiny. That said, in cases involving objections to government mandates, courts may apply strict scrutiny, requiring the government to show compelling interest, e.g., public health, that the mandate is narrowly tailored and least restrictive. Incorrect answers. A. Absolute religious freedom does not override public health measures. C. The rational basis test is too weak for fundamental rights cases. D. Public employees retain constitutional protections. Question 17. In a case where multiple parties have different objectives, a city government contracts a private company to install a new water filtration system. The contract stipulates completion within 12 months, but halfway through, the company argues that unforeseen supply chain disruptions make timely completion impossible. The city insists the deadline is non-negotiable. What legal principle could determine whether the company can be excused from fulfilling contract? A. The doctrine of impossibility of performance. B. The para evidence rule. C. The statute of frauds. D. The economic loss rule. Answer A. The doctrine of impossibility of performance. Explanation. The impossibility of performance doctrine allows a party to be excused from contractual obligations if unforeseen events make performance objectively impossible, e.g., a natural disaster destroys critical infrastructure. If supply chain issues are severe enough, e.g., global shortages, the company may be excused. Incorrect answers. B. The parallel evidence rule governs modifications, not unforeseen events. C. The statute of frauds concerns contract validity, not performance difficulties. D. The economic loss rule applies to tort claims, not contract breaches. Question 18. While managing a hybrid approach where timing issues arise, a multinational company transitions to a 4-day workweek while maintaining customer service availability. Employees in different time zones struggle to coordinate schedules. The company considers enforcing staggered shifts but faces resistance from unions. What legal principle governs whether the company can unilaterally impose scheduled changes? A. Employment doctrine allows the company to change work schedules freely. B. Collective bargaining agreements. C. BAS determines scheduled changes for unionized workers. C. The Fair Labor Standards Act, FLSA, prohibits schedule modifications. D. The Due Process Clause requires employee consent before schedule adjustments. Answer. B. Collective bargaining agreements. C. BAS determines scheduled changes for unionized workers. Explanation. If employees are unionized, their work schedules must comply with collective bargaining agreements. C. BAS negotiated between the employer and union. Unilateral changes may violate labor laws. Incorrect answers. A. Employment applies to non-unionized workers but does not override C. BAS. C. The FLS regulates wages and overtime, not schedule policies. D. The Due Process Clause applies to government actions, not private workplace policies. Question 19. In a high-stakes environment where multiple challenges arise, a national security agency begins mass data collection on internet users to prevent cyberterrorism. A privacy advocacy group sues, claiming the program violates Fourth Amendment rights. How might a court analyze the constitutionality of the surveillance program? A. The program is unconstitutional because mass surveillance lacks individualized suspicion. B. The program is constitutional under the third-party doctrine since users voluntarily share data. C. The program is lawful if conducted for national security purposes. D. The program is unconstitutional unless users explicitly consent to data collection. Answer. B. The program is constitutional under the third-party doctrine since users voluntarily share data. Explanation. Under the third-party doctrine, Smith v. Maryland, 1979, individuals lose Fourth Amendment protection over data shared with third parties, e.g., internet providers, phone companies. Courts have ruled that bulk metadata collection may be legal, though recent rulings have challenged mass surveillance practices. Incorrect answers. A. While suspicion is important, metadata collection may not require it. C. National security does not automatically override constitutional rights. D. Explicit consent is not always required under current legal interpretations. Question 20. During a comprehensive review of a process that needs improvement, a hospital revises its informed consent procedures for surgeries. A patient undergoes a high-risk operation but later sues, claiming they were not adequately informed of potential complications. What legal principle determines whether the hospital properly obtained consent? A. Respondit superior. B. Express warranty. C. Doctrine of informed consent. D. Negligence per se. Answer. C. Doctrine of informed consent. Explanation. The doctrine of informed consent requires medical providers to fully disclose risks, benefits, and alternatives before obtaining a patient's voluntary agreement to treatment. Incorrect answers. A. Respondit superior holds employers liable for employees' actions but does not determine consent. B. Express warranty applies to product guarantees, not medical procedures. D. Negligence applies when statutory violations lead to harm but does not specifically govern informed consent. Question 21. When scaling up operations that experience significant regulatory scrutiny, a tech company launches a new AI-based hiring system that analyzes resumes and predicts candidate success. After complaints of discrimination, a federal agency investigates the algorithm's bias against minority applicants. Under what law could the company face legal action? A. Title Omen of the Civil Rights Act of 1964. B. The Americans with Disabilities Act, ADA. C. The Communications Decency Act, EDA. D. The Digital Millennium Copyright Act, DAE. Answer A. Title Omen of the Civil Rights Act of 1964. Explanation. Title Omen prohibits employment discrimination based on race, color, religion, sex, or national origin. If an AI system disproportionately excludes minority applicants, the company may be liable under disparate impact claims. Incorrect answers. B. The ADA protects disabled individuals, but does not apply broadly to AI bias. C. The CD. Concerns online content regulation, not hiring discrimination. D. The DSEA protects copyrights, not employment practices. Question 22. When implementing new protocols in a shared environment, a pharmaceutical company introduces a stringent new policy requiring all employees to undergo random drug testing. A group of employees challenges the policy, arguing that it violates their privacy rights under state law. What key legal principle will determine the policy's enforceability? A. The Fourth Amendment's protection against unreasonable searches and seizures. B. The doctrine of employment at will. C. State labor laws and collective bargaining agreements. CBAS. D. The Occupational Safety and Health Act OSHA. Answer C. State labor laws and collective bargaining agreements. CBAS. Explanation. Private employers are generally not bound by the Fourth Amendment, which applies to government actions. Instead, state labor laws and CBAS, if applicable, determine whether drug testing policies are lawful. Some states impose stricter privacy protections, while others give employers broad discretion. Incorrect answers. A. The Fourth Amendment applies to government employers. Private companies. B. That where employment allows termination for any legal reason but does not dictate drug testing policies. D. OSHA regulates workplace safety but does not directly control drug testing policies. Question 23. In a situation where formal requirements conflict with evolving technologies, an e-commerce company expands into digital currency payments. However, federal regulations on cryptocurrency transactions impose strict reporting requirements. The company struggles to balance innovation with compliance. What legal framework primarily governs cryptocurrency transactions in the U.S.? A. The Securities Exchange Act of 1934. B. The Bank Secrecy Act, BSA, and Anti-Money Laundering (MA) regulations. C. The Uniform Commercial Code (UC). D. The Federal Trade Commission (FTC) Act. Answer B. The Bank Secrecy Act, BSA, and Anti-Money Laundering (ML) regulations. Explanation. Cryptocurrency exchanges and businesses handling digital assets must comply with BSA and ML regulations, which require customer identity verification, reporting of suspicious transactions, and anti-fraud measures. The SEC may also regulate some cryptocurrencies as securities, depending on how they function. Incorrect answers. The Securities Exchange Act applies to traditional stocks and bonds, but may not cover all cryptocurrencies. C. The Act governs general commercial transactions, but does not provide a framework for crypto. D. The FTC regulates deceptive business practices but does not oversee crypto compliance. Question 24. During a major transformation where existing methods are phased out, a university decides to replace physical textbooks with digital learning materials. Faculty members file a lawsuit claiming that the change violates their academic freedom and contractual rights. What legal principle is most relevant to resolving this dispute? A. The Americans with Disabilities Act, ADA. B. Intellectual property laws governing educational materials. C. Contract law and tenure agreements. D. The First Amendment's free speech clause. Answer C. Contract law and tenure agreements. Explanation. Faculty contracts and tenure agreements dictate whether the university can unilaterally change teaching materials. Some contracts protect academic freedom, while others allow administrative discretion. Incorrect answers. A. The ADA applies to accessibility, not contractual disputes. B. Intellectual property laws govern ownership of materials, but not faculty contracts. D. Feature protections apply to government restrictions, not employer policies. Question 25. While investigating a complicated issue between different regulatory bodies, a biotech firm develops a gene editing technology. Federal agencies disagree on which laws govern its use, leading to delays in approval. What legal principle determines which agency has jurisdiction? A. The Chevron Doctrine. B. The Dormant Commerce Clause. C. The Takings Clause. D. The Rule Against Perpetuities. Answer A. The Chevron Doctrine. Explanation. The Chevron Doctrine, Chevron U.S. stating that EDC 1984 holds that courts defer to agency interpretations of ambiguous laws if the agency's interpretation is reasonable. If multiple agencies have overlapping authority, e.g. FDA or DIA, ought to determine which agency's rule prevails. Incorrect answers. B. The Dormant Commerce Clause governs state restrictions on interstate commerce. C. The Takings Clause concerns government seizure of private property. D. The Rule Against Perpetuities applies to estate law, not administrative regulation. Question 26. In an environment where different components must interact efficiently, a major airline company integrates AI-driven scheduling software. Pilots argue that the algorithm leads to erratic schedules, violating their collective bargaining agreement. What legal principle determines whether the company must negotiate schedule changes? A. National Labor Relations Act Era. B. The Sherman Antitrust Act. C. The Federal Arbitration Act. D. The Lanham Act. Answer: A National Labor Relations Act Era. Explanation: ERA requires employers to bargain over working conditions, including schedules, if employees are unionized. AI-driven decisions do not override labor laws, and employers must negotiate changes that impact working conditions. Incorrect answers: B. The Sherman Act governs antitrust law, not employment conditions. C. The FA enforces arbitration agreements but does not dictate labor negotiations. D. The Lanham Act concerns trademarks, not labor disputes. Question 27. When improving a process that shows unexpected results, a city government implements a predictive policing system to prevent crime. Civil rights advocates claim the system disproportionately targets minority communities. What legal argument is most relevant? A. Equal protection clause under the 14th Amendment. B. The 5th Amendment's due process clause. C. The Commerce Clause. D. The Fair Credit Reporting Act of CRA. Answer: A. Equal Protection Clause under the 14th Amendment. Explanation: the Equal Protection Clause prohibits government policies that discriminate against specific racial or ethnic groups. If predictive policing disproportionately impacts minorities, it may face constitutional challenges. Incorrect answers: B. The Due Process Clause ensures fairness but does not directly govern racial discrimination. C. The Commerce Clause regulates interstate business, not local policing. D. The IFCRA applies to consumer credit reporting, not law enforcement. Question 28. While managing a hybrid approach where timing issues arise, a logistics company integrates self-driving trucks into its fleet. Regulators question whether traditional labor laws apply AI-driven vehicles. What legal challenge does this present? A. Determining liability for accidents involving AI-operated vehicles. B. The applicability of minimum wage laws to AI systems. C. Defining AI as a legal person for contract enforcement. D. Whether AI systems require work visas for international operations. Answer: A. Determining liability for accidents involving AI-operated vehicles. Explanation: AI-driven vehicle accidents raise complex liability issues, including whether the manufacturer, software developer, or user is responsible. Courts apply product liability laws and negligence principles to determine fault. Incorrect answers: B. AI systems are not employees, so wage laws do not apply. C. AI is not recognized as a person. D. Work visas apply to human workers, not AI. Question 29. During an emergency response where multiple areas are impacted, a government agency deploys drone technology to assess disaster zones. Residents file a lawsuit arguing that the use of drones violates their privacy rights. What legal principle is most relevant in determining whether the government's actions are lawful? A. The Fourth Amendment's protection against unreasonable searches. B. The Takings Clause of the Fifth Amendment. C. The Communications Decency Act, CDA. D. The Federal Aviation Administration. 4. Drone regulations. Answer: A. The Fourth Amendment's protection against unreasonable searches. Explanation: the Fourth Amendment protects against unwarranted government surveillance. Courts must determine if drones collecting visual data in private areas constitute an unreasonable search, balancing public safety interests against individual privacy rights. Incorrect answers: B. The Takings Clause applies to property seizures, not surveillance. C. The CDA governs online liability, not drone surveillance. D. FAO regulations set operational rules, but do not address constitutional privacy concerns. Question 30. In a multi-location scenario where consistency requirements vary, a fast food franchise requires all locations to implement biometric fingerprint scanning for employee timekeeping. Some states have strict laws regulating biometric data collection, leading to compliance challenges. What legal framework primarily governs biometric data usage in the U.S.? A. The Biometric Information Privacy Act, BIPA. B. The Family and Medical Leave Act, FLA. C. The Computer Fraud and Abuse Act, CIFA. D. The Sarbanes-Oxley Act, SOX. Answer: A. The Biometric Information Privacy Act, BIPA. Explanation: Illinois BEPA is one of the strictest biometric privacy laws in the US, requiring explicit consent before collecting or storing biometric data. Other states have varied regulations, creating legal challenges for companies operating nationwide. Incorrect answers. B. The FLA governs employee leave policies, not biometric data. C. The CFA focuses on cybersecurity and hacking, not biometric privacy. D. SOX regulates corporate financial practices, not employee data collection.